Amanda Nugent, both of whom are very reputable, and I trust them. I read it and I thought, you know, I don't know, something in my gut, my client was a little off, but was telling me that she was involved in a lot of programs, and none of this was really in the report. And then on the eve of the disposition, it was a no FR rec, we did get her letters from her programs, and she said she had been trying to call the tribe and leave messages to get in contact with them. So I was like, fine, let's just call this expert witness. We got her on the phone, we cross-examined her. Turns out she hadn't talked to Mother at all. She talked to some relatives, but she never once got in contact with Mother. She made a couple attempts, but Mother was homeless and didn't really have a phone that was reliable. So her couple of attempts that came in a very short period of time, I didn't really think were sufficient. I asked her questions like, well, do you think it would have been helpful to know the programs that Mother is in and making your determination that this child that Mother shouldn't be getting reunification services with this child, and that you should be placing this child in a foster home? And these are things that she really wanted to know. Ultimately, it got continued, and my client screwed up a little bit, but it got continued for this expert to actually look into the programs, because these are things that really, if they're making a qualified statement as to why this child should be placed in foster care or why a parent shouldn't get FR, they need to have the information before them. So it's very important that, you know, if you need to ask for a continuance or press the expert about it. So that's really all I have to say about expert witnesses. Any questions? Yes?
So the last time I did this, I had an expert witness who testified by phone, who had not talked to my client, who had not talked to the person at the tribe who was very pro our client. She hadn't prepared a written report. She was really horrible. And so what we should have done is ask the court to not accept that witness's testimony and appoint a new expert?
Well,
or request a new expert be appointed by the tribe? What do you do in a situation
it's
like
not your burden, so I'm not
Right.
sure that, I mean, I think that they've put forth who they believe is their qualified expert witness. Number one, you can take the expert on voir dire.
Right.
Establish their qualifications first. I mean,
Right.
if you say they're not qualified, they're not qualified, and the department does not have their burden. Number two, if the court says, you know, okay, this person's, like for instance, in this example, she probably would have qualified as having the requisite base of knowledge. She is a member of the tribe. She probably knows enough about their child rearing practices. She knows about the culture and community of the Rosebud Sioux tribe. She probably would have met the basic qualifications for an expert witness. But then you're attacking the substance of her testimony. They have to have testimony by a qualified expert witness that supports that there is clear and convincing evidence that continued custody by the parent would likely result in serious physical or emotional harm. If that expert hasn't done the appropriate research, then I think that your next option is to tell the court that I don't think that the court should consider this expert's testimony as reliable, because they haven't contacted all the people that they should have. And in that case where they haven't talked to the tribe, this is where I urge you so strongly. Some of the tribes will be very resistant. I have experienced this myself, even though I dealt with a lot of them, to speak to us. However, I urge you to try to contact the tribe and say, look, this is what's happening, and I know that you have a different position. Is there anyone that you can put forward? If you don't have the resources, do you have a recommendation? And we can get our own experts.
Have you ever had a tribe say, I know this person is saying they're an expert on our tribe, but we don't think they are?
Yes, that was Dr. Crespo trying to be an expert on when the tribe put forth an expert. They had a very detailed letter that they had given to the court, were available for cross-examination to provide live testimony. They had a completely different take than Dr. Crespo, who also had no knowledge of their cultural practices. And it did become a battle of the experts in that case. I put forth the tribe because the department, of course, is not going to bring their information before the court. We did have to get their letter in. I mean, the tribe was a party, they had intervened, so they did submit their letter as a party. And we called them and had them go up against Dr. Crespo, and the court weighed the two opinions, and it was pretty clear in that case. We had really good facts also, but it was pretty clear in that case who was the qualified expert witness.
So it goes to weight, but you can't exclude a witness that the tribe is saying, we don't think they are
Well,
knowledgeable about our tribe.
I mean, evidentiary rules still apply. I mean, if you have a way to do so under the basic evidence code. But I think that ultimately your first thing is to take them on voir dire and try and disqualify them there, and then ask the court to consider the weight of their testimony. No problem.
Thanks.
Yes.
I have been getting some sustained objections when I'm asking questions about who did you speak to. So, do you have any
Sustained on what basis?
on relevance?
So, because they say that there's nothing in the statute that says that they have to have an independent knowledge. So when we ask questions in that vein, those objections are always sustained.
Well, that's just puzzling, because relevance is not the objection. No, I can't think of any objection, but relevance is certainly, there is nothing written in the statute, that's true. I can look up I can see if there's any cases that are on point, but my argument would just be that it is entirely relevant because they're basing their opinion, we need to figure out what they're basing their opinion on. So if you don't know who they've talked to, what documents they've reviewed, how do you know what their opinion is based on? So, I mean, perhaps you could ask the question in a different way. Perhaps you can get to it by asking, what is your opinion based on? Did you speak to any persons in coming to this opinion? I don't know if maybe that helps to reframe it in a way where the court will understand that it is entirely relevant. But I don't know why she would be sustaining relevance objections to.
You're trying to get around it, but
She thinks it's sufficient if they rely on the social workers' reports. She thinks that's sufficient.
Okay, well, there are some BIA guidelines on that I will email. I can email out to you. That again are not persuasive or controlling, but they are informative to the court. They were set up by the Bureau of Indian Affairs to guide state courts in what they should be doing in ICWA cases with everything, with expert witnesses, with active efforts, with the standard of removal. So I will look that up. I don't have the site offhand, but I will look up the BIA guideline and email that to you, and maybe try that with her, because I know that she likes things in writing. Yes.
Just a comment. I'm wondering if the evidence code actually lays out what's required in order to qualify an expert witness. Is that
Yes, it is.
Well, yes, the basic rules of evidence do apply to all cases.
So then I think that's one way that you could bring it out, is that under the evidence code, this is how you would actually. That's just one way, I guess. You could do it.
In your voir dire.
Yeah.
So, but then it's part of taking you've got to be careful and make sure that you aren't just cross-examining them. You might want to take them on voir dire and say, are they actually qualified to make this statement about this family? Anything else about qualified expert witnesses? Okay. Active efforts. Now, active efforts are, it's funny, some courts treat them exactly the same as reasonable efforts. It's pretty clear that the statutory scheme and the congressional statements of purpose identify active efforts as something more than reasonable efforts. Exactly what that is, we don't really know yet. But there are examples out there. The code says that if you're seeking an involuntary foster care or termination of parental rights to an Indian child, then the department must satisfy the court that active efforts have been made, very similar to reasonable efforts needing to be satisfied in all of our cases. Now specifically, that means that remedial services and rehabilitative programs to prevent the breakup of the Indian family have been provided, and that those efforts have been unsuccessful. The clearest example that I can think of that is a case that I had where you have a mom who, it was substance abuse. It was pretty bad. Kids all get removed. There's 2 younger children and a teenager. Kids all get removed. Mom is doing really well, kind of with the expert witness requirement, bought us a little bit of time. She completes the program. She's clean, completely clean, done everything. She's got all of her certificates and she's made excellent progress and she's continuing in therapy. Teenager doesn't want to go home. She's having a really great time at Aunt and Uncle's. They let her do a lot of fun things and buy her a lot of really nice things. And so she doesn't want to go home to mom. Early on in the case, we had ordered conjoint counseling. We had requested conjoint counseling at every hearing. And we get an expert letter the day of, the expert also needs to testify about active efforts, just so we all know. It's not just the removal standard, it's also the expert should be testifying about active efforts. We get the expert letter and he says that active efforts have been provided to prevent the big breakup of this family. So I'm questioning him, well, what is the likely, what's likely to result in serious physical or emotional harm to this child, the teenager? Why can't she go home? Oh, well, you know, she just doesn't get along with her mom. Well, what could help with that? Well, probably therapy. Well, was there therapy put in place? No, but they tried. Well, how did they try? I mean, they didn't put in any referrals. There was never a referral for conjoint therapy until, I believe, the week before our contested dispo. And at that point, the child's therapist was saying, I need a little more time with this kid to determine whether conjoint is appropriate, because we all hate that classic order, conjoint, when approved by the, or if appropriate, as determined by the child's therapist. So basically, my argument and my question to him was, so have those efforts actually been provided to this family? And ultimately, no. And so how could we say that they were unsuccessful? You have to actually try. In all cases, frankly, but in ICWA cases, it's a much more enforceable standard, I think, and nonetheless, the court removed. But active efforts are important. Some of the BIA guidelines will say that if active efforts may mean that if a client is homeless and without a cell phone, that the department provides them with a phone. That's, there's no case law to support it, so I'm not saying that we can come into court and say, in right, whatever, says you have to provide my client with a phone, but it's something to consider, especially if they're asking your client to do random testing with calling the number daily and they don't have a phone. I mean, it doesn't have to be an expensive, you know, phone, obviously, but there are things that the active efforts means not just providing them with a bucket of referrals. I'd like to think that reasonable efforts means not just providing them with a bucket of referrals, but certainly active efforts means going with them to the UAII and making sure that they're getting the services they need. If they need a mental health assessment, going down there with them, making sure that the documents are delivered to whatever therapist or doctor needs them to complete an appropriate assessment of the family. And this applies at detention. So if the department, I mean, we should be bringing up reasonable efforts all the time, and more so we should be bringing up active efforts. And I would ask you to strive to think outside of the box when you're making an argument regarding active efforts, because there really is no explicit standard that says what active efforts is. So go ahead and think of what you think is reasonable and then take it one step further and argue it to the court. You know, you have nothing to lose, and at some point, hopefully, we're going to get some case law that explicitly tells us what active efforts really means. But it's a good tool to use, and it certainly is important to bring up in your ICWA cases. Now, as part of active efforts, the department is required to actually utilize the resources of the Indian Child's extended family tribe and other Indian social family tribe, tribal, and other Indian social service agencies. This means that they should not be able to get away with not contacting the tribe, Mr. Sneal. So they have to contact the tribe as part of active efforts. So if the social worker has not made any attempts to contact the tribe, and you're getting a letter from an expert witness that is not a tribal member, has no affiliation with the tribe, which I'm seeing more and more being put forth in our courts, that is something that you definitely need to bring up to the court. If the court is allowing relevance objections to that, maybe you bring it up beforehand. Maybe you conference it. You do what you need to, because absolutely the tribe needs to be contacted in these cases. They are a big part of this. Many tribes have resources outside of our limited Los Angeles County resources. I did provide one of the links on the last page is to the Indian Health Services, Southern California health programs. There are limited resources for our clients in LA County, including the Robert Sundance Family Wellness Center. They offer outpatient and substance abuse classes specifically for Indian tribal members or people who have Indian heritage even. The UAII is a great facility that has tons of services, not just limited to substance abuse like the Robert Sundance. And then the LA American Indian Health Program, which is a care collaborative program. You might be able to get your client to see a psychiatrist through that program if they need to get a doctor to give them a diagnosis and make sure they're taking the appropriate meds. However, it is the department's responsibility to be utilizing these efforts, and I urge you to bring that up to the court, because it can become, just as reasonable efforts can become very important down the line for our clients, active efforts is the same way. You have to make that finding at every stage, and you have to be able to make it supported by evidence. Any questions about active efforts? Okay. It's really hot in here, right? I'm like melting. Sorry, guys. So placement preferences. This, I had a little bit of trouble creating these slides because of a recent case that came down out of what's now 421. It's not citable yet because it's on appeal, as I understand it. But I'll take you through what the law presently says and kind of explain to you a little bit how that's getting shaken up. Placement preferences. This applies to any out-of-home placement. But very important is that any foster care placement or pre-adoptive placement must be in the least restrictive setting and within reasonable proximity to the child's home. Both of these are without taking into account any special needs of the child. But what this means is that during reunification, you don't place the child in Oklahoma with their relatives. You don't place the child out of state on the reservation. Unless the parents want to, unless there's good cause otherwise, which could include the parents agreeing to this. So first and foremost, when you're dealing with foster care placement or pre-adoptive placement, you're trying to look at the least restrictive setting within the placement preferences, but reasonable proximity for visitation, really, is what it boils down to. So now, the order of preference generally, I think I noted on the last slide that there are separate statutes for adoptive placement and foster care or pre-adoptive placement. For your guys' purposes, you can read the statutes. They're on the handout that I gave you. For your guys' purposes, I sort of just boiled it down to the 3 categories. This is not exactly what the statute says, but your order of preference generally is you're looking at a member of the child's extended family. So any family member, it's defined by statute as noted there, but first and foremost, it's defined by the tribe's law or custom. So if the tribe says that